Everyone. I'm absolutely staggered here because we've got somebody uh, coming in from India. So welcome. Um, okay, so today's topic is about materials costs, so inflation, and who bears the cost under predominantly NEC. So these are the issues that we're going to look at. We're going to look at the NEC compensation events because that's how, as a contractor or subcontractor, you claim extra time and money um, under NEC. I'm also going to kind of touch on the JCT form of contract and also consider how these contracts are likely to be amended, just so that as a contractor or subcontractor, you protect yourself. Um, and how also you might want to think about amending the contract to protect yourself from the inflationary pressures that we are seeing. So is it true? Is inflation true? Well, I think we need to kind of step back a little bit, because I think we've sort of got a bit embroiled in the Ukraine situation, but we need to remember that this has been going on for a little while now. It predates, the inflation predates the Ukraine situation. So back in June 2021, if you remember, the Ukraine war started at the very start of this year. But back in June 2021, we were seeing materials shortages. So it was a kind of perfect storm in terms of we'd had COVID, we had the Suez issue where the boat got stuck, and then a huge amount of demand as we were coming out of COVID. So even in September, that's the third bullet point, prices were rising, and it seemed to be across the board. Now, if you're interested in statistics, you can always say, well, for example, if you look back to the global recession back in 2007, 2008, steel prices massively increased. But if you look at the statistics, the increases that we've seen this last, 12 to 18 months have just been phenomenal. I probably don't need to tell you that. So fifth bullet point down, initially, it was linked to COVID, the Suez issue, potentially Brexit. And then at the start of this year, as I say, we started seeing supply problems, partly also caused by Russia and the Ukraine situation. Now, my intel at the moment is that the problem is easing slightly, but that it is still problematic. Obviously, you will have your own individual perception on that and your own individual challenges. But why I wanted to revisit this topic is that some of the projects which were possibly signed up to as lump sum contracts, fixed price contracts, January last year, on the basis of prices then, which were probably quite low, will have been hit by the issues that we've been seeing over the last year or so. So it might be, that now you're starting to look at what to do about them. So first of all, if we look at the NEC form of contract, so how is the how do you claim inflationary increases under NEC? Well, it's a compensation event under optional clause X1. So as we know, most of the compensation events are under clause 60 within NEC, but there are additional ones dotted around, predominantly in those optional X clauses. X1's the first one. It's optional, so that means that it either applies or not, depending upon whether a particular NEC form of contract in the contract data part 1 states that it applies. Typically, it will not apply because we've had years where inflation hasn't been a huge issue, save for a few discrete items back in 2007, 2008 that I referred to earlier. So, I wouldn't expect anyone, back in January 2021 to be thinking, oh, well, we need an inflation clause in our contract. Unless you just had very, very good foresight and you'd gauged that this was going to happen. So typically the only contracts where you would find X1 would be in a sort of long-term framework contract, so kind of 3 to 5 years, you might find that the X1 clause has been included. So let's just talk about how it works. You might be thinking, well, it doesn't apply to me because we've not got it included in any of our NEC contracts. But I think the lesson that we've learned from the last 2 years is that basically anything can happen, anything is possible. So, the old negotiations that we used to have, when we're, agreeing a contract where it's very much, is this likely to happen? Oh, I don't think it is. Okay, well, let's exclude it. I think there are good arguments to now be saying, well, is this likely to happen? No, I don't think it is. It's quite unlikely, but let's put it in anyway, because then if it does happen, contractor or subcontractor, depending on, who you're representing, is covered, and in support of that principle, we've seen a lot of things happen in the last 2 years where if at the start of the negotiations we had said, is a pandemic likely to happen? If we'd said that back in 2019, no, I don't think so. Right. Well, let's exclude any clauses that might cover it. The principle now, I think, should be, well, we've seen that anything can happen. So let's, ensure that the contract covers, all of those scenarios, no matter how unlikely they might seem. So how does it work if you can get it included into your contract? Well, it's as I've said, it's a price adjustment for inflation. So basically it operates for options A to D of your NEC contract. So A and B are fixed price, C and D are the pay and gain, so the profit sharing contracts. The fourth bullet point says options E and F don't require the inflation clauses because that's a sort of it's a kind of cost reimbursable contract. So contractors automatically paid its actual cost. So how does it work with regard to A and B, your fixed price contracts? Well, it basically means that it's a compensation event. So for all work carried out, you basically assess the inflationary impact upon that cost, and it's dealt with as a compensation event. How is it dealt with for options C and D? Well, the pay and gain element, the sharing at the end of the project, where you basically try and work out what the cost of the actual project has been as against the target. This clause alters the target cost, so it increases it so that you can calculate the pay and gain element. Also bear in mind, so, just going back to, anyone who's sat there thinking, well, my contracts, I've got this problem with inflation, but none of my contracts contain this X1 clause. So where do I go with this? Do bear in mind that for compensation events under any contract, the claiming party, so the contractor or the subcontractor, is entitled to the actual cost. So if, for example, really simple example, a building's being built, an extra wing is going to be required. It's a compensation event. It's a totally new extra wing. It requires steel work to that building. Cost of steel work has shot up. Well, what the contractor recovers there is the actual cost of that steel work, even though it's substantially more than any steel work that might have been priced within the contract, because that extra wing of the building is a compensation event. So don't forget that. Don't lose your opportunity to claim your actual costs, so what you've actually paid. So that includes any inflationary elements within your compensation events. So how does X1 work? Well, it's complicated, or I find it complicated anyway. As you would expect with NEC, it's a mixture of, you look at X1, so the optional X clauses in the contract, but a lot of it refers back to the contract data. So the contract data part 1 and part 2. So you need to make sure that if X1 is going to be included, that the contract data has been completed as required. So the first point to bear in mind is that, as you would imagine with an inflation clause, there needs to be a way of measuring the inflation. It's all very well saying, oh, well, the cost of steel has increased, by 20% since I bought it two weeks ago or 3 months ago. But that's not really a satisfactory method. So there are all sorts of, retail prices index, all these indices that we have. One of them will typically be used to measure inflation. So, bear that in mind. Bear in mind when you're thinking about this clause, which index you want to use, and also whether it will adequately cover all elements, because of course we've seen quite a bizarre situation where, and it's probably always the same if you've got high inflationary pressures, where some things are more susceptible to inflationary increases and bigger increases. This means that if you're using the indices, there's always going to be a sort of rounding up or rounding down element, because the RPI is based on all retail prices. Whereas, if you're purchasing a particular item, it might have increased substantially more than, the sort of average. So just bear that point in mind. It's sort of quite a practical point. There's also a requirement in the contract data to include a base date. So that's the date from which the inflationary increases are going to be calculated. So it says here, the guidance note says it's usually 4 to 6 weeks before the tender date. It's not the contract signing date, it's the tender date. And the logic there is, I think it's probably fairly obvious. But if it's 4 to 6, so if it's 6 weeks before the tender date, then contractor or subcontractor, as the case may be, is preparing its price. And it has, if it's 6 weeks, it has 6 weeks before the tender to get in all of its prices based upon the pricing at that point. And then, assuming that price is accepted, contracts entered into, move forward, inflation, goes up, increases prices by 10%. From that period, contractors entitled to those increases as a compensation event. So I think that's fairly easy to understand as a concept, but again, make sure, if you're getting X1 included in your contract, that the base date is, prior to, it's the basis, it's the date when you've based your prices from. The next point to be included is this third dash, the proportion of the value of the works to be linked to the index, which, you kind of think, well, what does that mean? That doesn't make sense. If you look at the final point, it says GN, which is the guidance notes for NEC, suggests there should be a 10% maximum is reasonable as the non-adjustable element. So what this means is that if you have a compensation event because prices have increased by 10%, the interim payments worked out on that basis. But if the proportion of the value of the works to be linked to the index is 90%, then that obviously means that 10% won't be adjusted for inflation. So it's sort of meaning that the contractor or the subcontractor, as the case may be, takes some of the risk. They take that 10%. So again, the key here is, when you're checking the contract with an X clause, you don't, if you're a contractor or a subcontractor, you're the party who's going to be wanting to be paid. You don't really want to be responsible for more than 10%. So the proportion of the value of the works to be linked to the index would be 90%. So how does the X1 work? Well, the first bullet point, the period that the inflationary increases apply goes up to the contract completion date. So that's the date in the contract, not the actual completion date. But, and this is where the compensation event point comes in that I referred to initially, if your work is extended beyond the completion date, then that part of the work is going to be a compensation event one way or another, probably because of prolongation. And you need to make sure that the inflationary increases are included within that compensation event. So that's why the inflation clause doesn't need to cover beyond the contract completion date, because beyond the contract completion date is a compensation event in itself, and therefore you need to remember to claim those inflation increases for that period within those CEs. How it's worked is that, so it says you have provisional index figures, and again, this is a sort of common sense thing. So we've talked about the indices that might be used, the retail prices index. There are all sorts of other ones. You probably wouldn't be using the RPI for construction work. And as you'll appreciate, those figures come out, so they will come out typically, monthly. But quite often, because they apply for that month, for example, they're probably provisional figures. They probably need finalising, just because, it applies to that month and they're coming out at the end of that month. So what happens is the compensation event is claimed on the provisional basis. And then when the figure is finalised by whichever body, whichever authority produces the particular index that the contract is based upon, once it's finalised, then there's a correcting mechanism within the contract. So next bullet point down, under options A and B, the inflation adjustment is made to the price for work done to date. So that's fairly simple. It basically operates as a compensation event, and it would increase, for example, in your option A, your activity schedule would be increased. Slightly different for options C and D, as I've already referred to. As I've said, the adjustment is made to the target figure. That's only relevant right at the end of the project, once the final account, and I'll use that term loosely, because of course under NEC3 we don't have a final account, but when the final payment is being determined, it's at that point that the pain, gain, and the sharing of that pain or gain, the profit or the loss, is calculated throughout the project. What happens is that the contractor, the party being paid, contractor or subcontractor, is paid under option E. So it automatically gets paid for its actual costs. So the inflation element is included in there. So that's how it works under options C and D. Just a note there. So we're going to look later on at about amendments to the contracts that might impact on this. just be careful with options C and D, because the standard NEC provides that that is how the pay and gain is calculated, i.e. paying the party being paid is paid under option E through the project, and then the adjustment to the pay and gain sharing is dealt with at the end. There has been case law on this, though, where I think reading between the lines, the project went into substantial pain. So the paying party, partway through the project, decided it didn't want to pay the other party any more money, because it knew that, or it considered that there was going to have to be a repayment back, because of the project was, quite obviously, in a pain, a loss situation. And the court said, no, you can't claw that money back until the end of the project. So what you need to look out for, just as an incidental here, as a contractor or a subcontractor, is the contract being amended to say that the pay and gain can be operated throughout the contract, which is what I would want to do if I was amending a contract on behalf of a paying party under C and D. So just keep an eye out for that. Just be careful as well, because arguably these provisions are compensating for financially. They're not giving extensions of time. And obviously what we saw, particularly at the start, so kind of through the back end of 2021, was delays as well as price increases. So delays in delivery, and particularly in delivery of things that were coming from outside of the UK. So, your time is probably not going to be able to be recovered on that clause. You need to find another clause to claim it under. So that's X1 for inflation. So if you haven't got that clause in your contract, what else might assist? And also, these are clauses that might assist if you're looking at it from the other side, in terms of contracts in the future. How do you protect yourself as a contractor or a subcontractor from delays to materials or inflationary pressures? So other potential CEs, and I think this is also quite, a good way of looking, a good opportunity to look at the CEs to see what you can claim and what you can't claim under them, because so often the CE that we focus on, or the CEs we focus on, are weather, ground conditions, and the major one is the first CE, which is basically a change to the scope or the works information, whichever contract you're on. So this is CE3. So it says, the first bullet point says 60.13 in brackets. It's the third compensation event at clause 60. So this is a compensation event. So it entitles the party doing the work to a compensation event where the employer or the client, so in a subcontract, that includes where the contractor does not provide something that it is to provide. And this is the critical point: by the date in the accepted programme. That's the key point. It's not just that one of the parties, so the employer stroke client or contractor in a subcontract, doesn't provide something. It's something that the accepted programme specifically states that it needs to provide. Now, why is it so specific? Well, of course, it's specific because NEC is this very prescriptive contract. So whereas on JCT, it might tend to be more worded as something that the employer or client should reasonably have provided by a certain date, it's prescriptive here. So contractors, subcontractors in subcontracts, you need to make sure your accepted programme reflects what the employer stroke client stroke contractor is going to provide and the date when you require it by, so that as soon as it's not provided, then it can be notified as a compensation event. So that, yeah. So I think that's everything covered there. So other potential compensation events, and these are very much in the same ilk. So 60.15, so the fifth compensation event in clause 60. So the employer or others in this case. Now others, it is defined, and be careful that this isn't amended, but under the standard NEC, it's basically other people who are engaged by the employer, other people doing work. So it's a situation where they do not do work within the times specified in either the accepted programme or within the conditions in the works information, so that's WI stroke scope, or carry out works that is not stated in the works information. So it's either they don't do what the contract documents say that they do within the timescales set out in the contract documents, or they carry out extra things that aren't in the works information or scope. So that latter one, if that latter one's an easier one, because if anything is done that's not by the employer or others, that's not in the works information or in the accepted programme, then that's automatically a compensation event. But if they don't do things that, if it's something positive that they have to do, and we're saying subcontractor is saying it hasn't been done, then it has to have been either included in the accepted programme or it's set out within the works information and scope. So what does that mean? Well, first of all, it means that the works information and scope have to be very specific. It's no good saying the employer stroke others are going to do all of this work at some point through the project or at some point whilst contractors stroke subcontractors on site, because you're never going to find a breach of that, because it's just generally at some point. So that's if they do it at any time that's an inconvenience to the contractor or subcontractor, it's still within the conditions of the works information or the scope. So the works information or scope has to be really specific. Employer's going to do this work, it's going to be done between these dates. And I think that's particularly important because bear in mind, the accepted programme, unless it is appended to the contract, it's something that is agreed after the contract has been signed. So it's no good relying on that as being the contractor or the subcontractor's ability to claim a compensation event. Because what happens if, for example, for example, the works information and scope are pretty vague, this kind of scenario I've just referred to. And then contract is signed, contractor goes on site, submits its first programme for acceptance. And within it, it thinks, I need to cover off this vague works information stroke scope. So in its accepted programme, it says, actually between the 5th and the 10th of February, employer's going to carry out that work that's referred to in the works information stroke scope. What they're going to find is that the project manager rejects that programme as not being valid because it's not in compliance with the works information, because the works information is vague. So one way or another, either the works information needs to be specific and or the accepted programme needs to be accepted pre-contract and specifically included in the contract as a contract document, and specifically state when the work by the employer, work by others is going to be carried out. Second bullet point, note, as you'd expect, it doesn't apply to the contractors, subcontractors being delayed, because as we know, the contractor is always responsible for its subcontractors and its subconsultants. So moving down to the third bullet point, so the 14th compensation event is an event occurs, which is the employer stroke client's risk. So this, I mean, I mentioned this, but it's unlikely to be something that will help you in this situation. It's just that we've covered them all. This would really rely upon the works information or the scope or the contract itself having been amended to add extra risks onto the employer stroke the client's list of risks, which is unlikely to have happened unless that's specifically been negotiated. The next one down, the final bullet point, is compensation event 16. So the employer or client, again, whichever term you're using, fails to provide materials, facilities, or samples for testing or inspection as set out in the works information or scope. So this is quite a discrete situation. It's probably going to be towards the end of the project because it's about testing and inspection. It might not be. It might be part way through the project, but it's to do with the employer, the client, providing materials, facilities, or samples to be tested at some point in the project, and it doesn't provide them, so that testing or inspection can't proceed. Again, I think this would be an unusual situation to be able to claim for materials under it. And then the final compensation event is compensation event 19, which you might recognise because we looked at that in the context of the COVID lockdowns, etc. And it's your force majeure clause. So it's basically something that force majeure is more that prevents a project from being completed because of an issue that nobody could have, neither party could have reasonably have prevented. But arguably, it applies to this situation. So it's an event which stops, sorry, that's a typo, stops for, it should be stops or delays. It's amazing, isn't it, how you spot them immediately, despite having checked the slides beforehand. Stops or delays the contractor or subcontractor from completing the work. So that's the first criteria. It's got to stop or delay. So normally it would be delay. It's not going to kind of totally prevent completion. So it delays prevention. It's got to be something that neither party, so this is the second line, neither party could prevent, and that an experienced contractor would have judged the issue to have had such a small chance of occurring that it would be unreasonable to have allowed for it in the price. So you're looking in that criteria, that third criteria, you're looking back to when contractor or subcontractor priced, would it have been reasonable to have allowed for inflation, back in 2019, 2020, I don't see why it would. 2021, no. But, would it have been reasonable for the contractor to have allowed for inflation summer last year? Probably yes, because by then we were seeing the press reporting on inflation. So at that point, an experienced contractor would have realised that inflation was an issue. So, there are certain times when this type of claim might succeed, but I suspect that after the summer of last year up until now, if you're making a claim under this clause, it's going to be really, really tricky. So it's delay related. So arguably it doesn't, it's not going to be helpful for a price increase. And particularly if there's no delay, then I don't think it's going to work for just a price increase at all. The next point down, it's not going to assist in circumstances where the contract was signed after the shortages and delays and inflationary increases were being reported upon, because obviously an experienced contractor would have judged that that issue, had a large chance of occurring. So yeah, as it says, might assist for older contracts where there's been delay. So is there anything else in NEC which might assist? No, not in the standard form. Compensation events are the contractor's only real remedy, except for the acceleration clause, which isn't relevant here. Obviously, it's subject to the standard NEC being amended, and we'll come to a few ways in which you might want to try and amend NEC to assist with this situation. As regards JCT, just touch on this really, really quickly. Generally, it's very similar to NEC. There is a fluctuations clause. It's an optional clause, and again, not used very often is probably an understatement. And again, VOs, variations, EOT, extension of time, L&D, loss and expense, they're all sort of similar to compensation events, as in compensation events encompass all of those items. Slightly different grounds, but the principle is the same. You really are safest to get that fluctuations clause included in the same way. The safest way is to get that NEC X1 included. So common amendments. So these are amendments that will prevent a contractor or subcontractor being able to make a claim. So X1 not included generally. So this is the point that I made earlier, that it's an optional clause. So if you're entering into an NEC contract, you need to make sure that the contract data part 1 completed by the paying party, that it specifically says that X1 is included. And as we've seen already, that all the relevant information about the indices to use, etc., is included. So it's a proper clause that can be operated. If there are blanks and bits that aren't completed in the contract data with regard to the clause, then it's probably going to be impossible to operate. 60.119, so CE 19, which is the one that we've just looked at about force majeure, so something happening that nobody anticipated. Quite often, particularly post-COVID, it's being amended to reduce its scope or remove it completely. So just be careful about that. And again, the position, is, as I've already referred to, in your negotiations as a contractor or subcontract, you want to be saying to the paying party, why is this being removed? Now, what we've seen over the past 2 years shows that now, more than ever, that clause needs including, because what we've seen over the past 2 years is that things that we thought, would never happen have happened. There's an 8-week in the contract as a deadline, a time limit to notify compensation events. So that is the contractor's obligation. And if it's not notified within 8 weeks, the claim is time barred. So no extra time, no extra money. So really, really harsh, but the courts will operate this clause. So don't forget about that clause. But also be aware that typically it's amended. Quite often it's reduced down to 4 weeks. There's a similar time scale. I can never remember whether it's 6 or 7 weeks in the subcontract. But again, be careful, because often that time scale is reduced. So same implication. If you don't notify within the time scale, you have no entitlement, but you've still got to do the work. So just be really careful about that. And then finally, there's a real trend at the moment to put a clause in both JCT and NEC to say that if you've got concurrent delay, and one of those delays is a compensation event, and one is something that the contractor has caused, without that, in that scenario, the contractor bears the financial risk of that delay. Now, ordinarily, under the contracts, NEC and JCT, without that clause, the contractor would get an extension of time. Under NEC, it would also get its loss and expense. So just be careful about that clause, because it's amazing how often we do see concurrent delay. So, delay that's caused by two causes, one being a cause that is the employer's risk, and one being a cause that's the contractor's risk. So in terms of what are the options, so what we've just been looking at in the previous slide was how typically an employer, a client might amend the NEC form of contract, basically to make it trickier, to put more risk upon the contractor, the party doing the work, or the subcontractor and a subcontract. So we're now going to look at some of the ways in which the NEC form of contract can be amended in order to protect or help protect the contractor from inflation and delays due to materials shortages and supply and demand issues. Now, first of all, bear in mind, big caveat here, one issue that I see habitually is contractor or subcontractor submits its tender with a list of caveats, might be a long list, might be a short list, and then the contract is signed, but that list of caveats isn't included or incorporated anyway into the contract, which means that none of those caveats, none of those exclusions apply to the contract. So I see this typically with ground conditions, where a contractor may submit a price and say, but it excludes the a cost of any ground conditions other than those set out in the ground conditions report that as part of the ITT, for example. Contract, as I say, is then signed. It doesn't include that caveat, which means that the contractor, despite what it said in its tender, is responsible for all ground conditions. So if you put in caveats in your tender, make sure they find their way into the contract and are clearly drafted, because that's another big problem. NEC doesn't like its contract being amended because it often causes the contract to be ambiguous. So be really careful about this. So the first, the first and the easy way to kind of overcome the inflationary issues are to persuade the client or the employer to contract on option E. That's the easy way of doing it. But I suspect persuading the client stroke employer that option E is the way to go will be tricky. So another option is to persuade, and this is all in the contract negotiation, so it would need to be incorporated into the contract. So persuade the client stroke employer to amend the scope stroke works information so that employer obtains the relevant materials, or it could be worded that it's the employer's risk, so that if there are delays, but also if there are price increases, there can be compensation events in accordance with the items that we've looked at. Again, the drafting would need to be done very carefully. So, you're probably going to need to get somebody to do it, probably your legal advisor. And, I don't like in these webinars, to send you off to your lawyer. But, these things, I always think it's a real shame that, if you've agreed a principle, that, it then becomes inoperable as a principle because it hasn't been incorporated into the contract properly. Because, for example, if you have your list of caveats, and that gets attached to the contract, there might be no reference to it in the contract itself. So, what status does it have? Even if it says, there is a list of caveats at the end, the likelihood is that there are other clauses within the contract that might conflict with it. So it does need to be done carefully. You would then need to, with this option, to ensure that the scope, works information, and the accepted programme all reflected the above, so that you didn't have a discrepancy where works information is vague as to, for example, what the employer is going to provide, but then you have a clause in the contract that's more specific. As the next bullet point says, don't forget delay. So when you're looking at making something an extra compensation event, or, kind of almost shoehorning certain events or issues into a compensation event, make sure that delay as well as cost is included. What you can do is incorporate provisional sums provisions into NEC. So you could do that as a Z clause. Again, be careful with the drafting, and again, make sure that it covers your specific circumstances and that it includes cost and time. And then other alternatives. So one alternative is to sort of use a two-stage contracting provision, which we do have as another X clause in NEC 4. It's not in NEC 3, but that allows certain work to be done before the final price is agreed. So, that could be adapted, but again, it will require amendments, so be careful. You could also use sort of letter of intent as a two-stage contracting, but again, you would need to be careful with the drafting. And of course, at the end of the day, you're still in this scenario, looking at presumably a fixed price contract. So, as soon as that fixed price contract is executed, the contractor, subcontractor in a subcontract scenario, is responsible for inflationary increases from then on, in the way that, I've been discussing today. So, just be careful about that. Another option is to have a bespoke amendment to create an additional compensation event. So that could just be, saying that, any inflation, and kind of just ignore the X1. It might be possible to, I haven't had a go myself, but it might be possible just to have a fairly simple inflationary clause. I wouldn't advocate drafting it yourself, because I think hopefully you'll have seen from all the requirements in the X1 clause, there's a reason why these clauses are quite technical and quite complicated, because you need to be able to be certain as to how they should be calculated. Otherwise, they'll fail for uncertainty at law. So what you could have, and we kind of see this quite often, what we see is that compensation event 19, force majeure, being removed, but a separate clause being put in as an alternative to cover the COVID-19 situation. We saw quite a lot of that kind of following, March 2020, where there was a sort of sharing of the COVID risk. Unfortunately, I think a lot of those sharing clauses were quite specific. So they covered things like, it was sort of, any delays any delay or extra cost specifically caused by changes in the COVID regulations. And unfortunately, because the COVID regulations didn't massively change in terms of how construction projects operated, a lot of them, aren't particularly helpful to contractors and subcontractors. And ditto Brexit clauses, we saw provisions saying that contractors, subcontractors were responsible for Brexit, unless it meant, for example, an extra customs and excise or duty was charged for items coming into the country. And that's not been the major issue with Brexit. There've been other issues for construction, so those claims typically have been very limited. So, you just have to be quite careful. So yes, the final point is be wary of all amendments. NEC counsels against amending. So, these, it's kind of rare that, I do a seminar about, just amending from a contractor or subcontractor perspective. What we're used to in construction, unfortunately for contractors and subcontractors, is, the contracts being massively amended to move the risk from the paying party to the party doing the work. We're not used to it being amended the other way around. So just be careful. Don't be tempted, as I say, to have a go at amending it yourself, because it could be a false economy. So that's everything for today. Just wondering, oh, Gemma's ahead of me already. Just wondering if we have any questions. Doesn't look like we have. My email address is there, so do feel free. Here they're coming. Do feel free to send through any email questions in the next week or so. If you have any. So Dave's question, hi Dave. If the contract is NEC option B and there was a change in the scope that increased the quantities, would you be entitled to revisit the rate to take into account inflation? Now, I always have to look at this with option B, but there is a provision in option B that says if the change in quantities is it's a certain percentage, that's a relatively small percentage, then the only way it's not dealt with as a normal CE, so it's just dealt with almost by prorating the quantities price. It's only if you are over the quantities that it's calculated as a CE. But I think that yes, once it's a CE, the guidance notes say you're claiming your actual cost. So yes, I think the answer to that, would be yes, providing it's sufficient of an increase. All right, Colin. Hi, Colin. So if X1 isn't allowed on a blanket framework contract, how best do we I mean, my view would be that when you're negotiating your framework contracts, particularly, I mean, if they're for a couple of years, historically, they maybe wouldn't have an inflationary provision. But I would say anything more than 2 years should have an inflation provision, because it's just too much of a commitment on a framework contract. So if, and I think, so if you're looking at a contract now, a framework contract to sign up to, and the other party isn't willing to agree in X1, they're basically saying, we aren't going to allow you any inflation. So I think the discussion then has to turn to, well, if you won't pay us for inflation, you've done the negotiations, you can't persuade the paying party to agree, well, then I think you need to consider kind of, suggesting some kind of compromise, possibly, okay, we don't have X1. Or what you could do is say, well, let's have X1, but, contractor, the party being paid, won't take 10% of the risk, as we saw before. It'll take 30%. That's reasonable. So you could go down that route. And I suppose if you're kind of constantly chipping away and you're making no progress, it looks like it's a sort of take it or leave it, as the party doing the work subject to inflation. You're either going to have to decide, do I want this work or don't I? The other option is to go and say, well, if you won't agree X1, can we agree that, we get an extension of time for delays caused by, blockages to the supply chain, but then you're going to have to actually factor in inflation into your price, and that's a negotiation point to say, well, if you don't want to pay for inflation, Mr. Client, Mrs. Employer, let's be completely basically it's going to be a company anyway, but if they don't want to pay for inflation, then it's going to be there's going to be a commensurate impact on the fixed price, because contractor is going to have to factor it in to the price. Or you go down the route that we've just looked at, where you do some kind of sharing. So Dave, if people are paid as a defined cost rather than actual cost interruption, is there a mechanism for recovering the impact of inflation? Well, if by defined costs, so I assume that, this would typically be, I think, under a framework contract again. So your defined cost are sort of fixed costs set out in the contract as a sort of amendment. So you're being paid your fixed costs, which are set out in stone in the contract. You're subject to inflationary pressures. It's going to increase your pain gain at the end. So hopefully it will, well, not hopefully, it'll increase your gain in that you won't eat into the pain gain mechanism. Well, yeah, but that's not going to be a great situation, because of course all you're going to do there is recover a percentage. So I think if you're on fixed costs and there's no inflation, then you're going to be struggling unless you can. I'm trying to think. I think it's probably quite a tricky situation. Unless you can argue that the items come within another CE event, and particularly the force majeure provision, which, as we've already discussed, might have been watered down, so probably not helpful. And that's everything. Thank you.
And I think that's it. Thank you very much, Sarah. Thank you, everyone, for this afternoon, and thank you for your questions. Everyone should receive a link. As I mentioned before, a few people had asked a link to a CPD certificate once this webinar completes. That'll be directly through Click Meeting. If anyone's got any issues, drop me a line, or a few people who couldn't log on have asked me for a copy of the recording. So once you've got that uploaded, we can send that along with a copy of the slides to everyone. I'd just like to thank Sarah once again for her time and fantastic presentation this afternoon. Thank you, everyone. I hope you enjoy the rest